Good morning, everybody. There we go. Starting to see folks come in. Thank you all for joining us today. We are going to hopefully get the last couple of people in from the waiting room and then get started for today. And I think that's it. That's all of us for today. All right. Thank you for joining us today. I'm going to start like I usually do with some Zoom housekeeping items, starting with reminding you that your toolbar is at the bottom of your screen. Probably it might be flashing because I just put a message into the chat. For the purposes of our Q&A today, if you could please stay muted during the course of the Zoom, that would be great. You can mute or unmute your audio using the audio button, which is also on that Zoom toolbar. That's also where your video button is located. You're welcome to be on camera or off today. Whatever works for you is fine with us. And the chat, which I just mentioned, I popped a message in there telling you how to look at our YouTube channel where you can see videos for past Q&A videos. And also it tells you how you can submit questions for future Q&As. We do ask that you try to get those to us by 4 p.m. on Monday, so we have the day on Tuesday to research as needed so that we can come to you with competent answers on Wednesdays during our Q&A. We do generally like to remind folks that the chat is really just for asking questions or requesting clarification, not for a lot of like discussion and back and forth like you might see on like the CAI message boards, for example. Another reminder that we give you every week is that we are here to discuss general information only, not to give legal advice. So, A, you can't get legal advice in this forum, and B, sometimes the questions that folks submit are really just way too specific for us to answer them without giving legal advice, and we can't do that in this forum. We can't do that for non-clients. We can't do that without having an attorney-client relationship established, of course. Sometimes the questions are so specific that we'll have to email you back and tell you that we can't answer them. Please don't shoot the messenger when that happens. Chelsea is not the one that decides these questions are too specific. It's me. So if you want to be mad at somebody, you can be mad at me. But we also would be doing you all a disservice if we were willing to answer questions that were too specific in this type of scenario, because without that attorney-client relationship established, without an understanding of your governing statute and the entirety of your governing documents, et cetera, we can't give competent legal advice anyways. The other thing that this means is that if somebody sends you like a link to our Q&A or a blog article or something that I wrote on LinkedIn or anything like that online that is intended to be general information and not legal advice, and they try to tell you that you have to do something or you can't do something because of what Valerie or Ken or Tima or whoever said, you can ignore them. Or better yet, go to your association attorney to ask for actual legal advice for your particular community and circumstances. So again, that's just a very long way of saying we're not here to give legal advice. We're just speaking generally about stuff that we think is helpful to community associations in Washington State and all of the different people that work with and serve them. We might have a little bit of extra time today for questions. So if you do have questions that you didn't have a chance to submit in advance, you're welcome to pop those into the chat and we will try to get to them if we are able to do that today. And then the last thing I want to tell everybody about is something I'm just putting a link into the chat for, which is that on Thursday this week, WSCAI's DEIB committee is sponsoring a webinar. It's an all-member webinar about barriers in housing. It's from 12 to 1:30, I believe. And the link that I put in the chat will take you to the event on the WSCAI website so that you can learn more about that. And we would love to see folks there if you are free and would like to do some learning around these issues over lunch on Thursday. So I think that's all I have for our announcements. And I'm going to go ahead and jump us into our first question. Why would we need to do an insurance deductible shifting amendment if that is how we are already handling things? What does Wakaiowa say about this issue, or is it silent? Does Wakaiowa force things to be this way without having to dedicate time and money on an amendment? If our declaration is essentially repealed by Wakaiowa on January 1, 2028, does anything at all survive? So, as you can see, this is a series of questions, not just one question, but I'm going to try to take them in order. So the first question is, why do we need an insurance deductible shifting amendment if this is already how we do things? And the short answer is that you don't have to do anything, right? You don't have to go out and get an amendment. But as an association, you may face liability if a court scrutinizes what you're doing, if it's not in your documents. So putting this differently, past practice that is not supported by the declaration puts the association at risk. Just because you've done something a certain way for a really long time does not mean that it's okay to keep doing it that way once you know that it's not supported by your governing documents. And ignorance of the fact that this was the wrong way to be doing things is not a defense in court. So the way the law works in Washington state is that uninsured repair costs have to be paid for in the manner in which the declaration for your community says they have to be paid for. And that includes amounts up to the deductible amount, right? Even if there is insurance, if you've got a $10,000 or $20,000 deductible, that deductible amount would be considered at the uninsured portion of the loss. Most declarations, the way that they are written, especially the older we get in terms of those documents, most of them do not provide the authority for the association to shift the deductible or other uninsured costs to the at-fault owner or unit, regardless of whether there's negligence or not. Some documents, it's more likely that there's a provision in the documents to pass on costs of negligence to the owner, but negligence is hard to prove, and so it's not as straightforward a thing as you might like. So I don't want to spend too much time on just one part of the question because there were multiple parts to the question. I want to get to those too. But the short answer is, if your documents don't provide for the authority to shift these costs to the unit owners, and you're doing it anyways, you're at risk if somebody challenges that action, and you are likely to lose if that kind of challenge ends up in front of a judge. So the next question is, what does Wakaiowa say about this issue? And does Wakaiowa force things to be this way without having to do an amendment? Wakaiowa does address insurance deductible shifting. It allows shifting only up to the amount that is provided for by the declaration. So if your current declaration does not allow it, then Wakaiowa will not allow it. So later on in your question, you asked about whether Wakaiowa essentially repeals your declaration or does anything survive at all. And the answer to that question is that the majority of the time when there is a conflict between your declaration and Wakaiowa, the statute will trump. But it's not always as simple as that, because the statute requires specific things, in particular in this scenario, in order to shift these uninsured costs to the owner. If you want to look at the section of Wakaiowa that is applicable here, it's RCW 6490-480. And it says that your declaration has to authorize deductible shifting. It also says that you have to give the owner notice and an opportunity to be heard before you can make a valid assessment for that deductible amount, even if you do have the correct language in your documents. So Wakaiowa will not make this an option for every community. It will only make it an option for the communities that have that option in their documents or that adopt an amendment to adopt this option in your documents. So I think that answers all of the questions. If you have any follow-ups, you're welcome to put them in the chat. And Tima, if you have anything you want to add, please feel free.
I mean, I would only add that this comes up from a practical standpoint. This comes up on the collection side relatively often, because we'll see a ledger with an insurance deductible added to the ledger, then we have to go back and validate it. And so when we're making these recommendations to our clients, often it's because they can't shift the deductible. They thought that they could, or maybe they had been in the past. And so we are having to tell our clients, no, we can't add this to the ledger, but also we are recommending that you consider an amendment to your declaration, because after January 1, 2028, there's basically, you might as well do it now. Nothing's going to change between now and January 1, 2028. So that's, I just was going to mention that because that's often where it comes up for us, at least on my side of things.
Yeah. And actually, now when you were talking, I thought of something else too, which is when we draft an insurance deductible shifting amendment, that's not the only thing that that type of amendment covers. We also include language around high risk components, inspection and replacement schedules, and other things about the maintenance of higher risk components or unit elements that are the most common ones to cause damage within the community. The other thing to think about is not even so much the contents of the amendment itself, which do matter, but it is getting more and more expensive for associations to obtain and maintain insurance coverage to replace and repair damage, caused by a variety of things within the community. And what that means is we've seen more and more things that are excluded from coverage. We've seen larger and larger deductibles and also just higher premiums, even with those deductibles increasing. And on a dollar for dollar basis, it is cheaper for an owner as part of their HO6 policy to provide for repair and replacement coverage when their unit causes damage within a community than it is for an association to maintain that level of insurance for every unit within the community. So another thing that we'll often see in an insurance shifting amendment like this is a very specific requirement that owners have their own HO6 policy. And a lot of times what we'll tell our clients when they're trying to get an insurance amendment adopted is tell your owners to take a copy of the amendment to their insurance agent, ask them if they already have this level of coverage, because many people do. And if they don't, ask them how much more it will cost them to get coverage so that when the $20,000 deductible is assessed to their unit, they have insurance coverage for that, subject to their own individual deductible. And what we often hear is that either people already have this type of coverage under their HO6 policy, or the cost of adding it is negligible, like $150 a year. That is way cheaper than what it costs a community association to maintain the type of coverage that would provide for that replacement value within the units. And it also not having to submit claims for claims that are less than the amount of the association's deductible. The ability to not submit claims to your insurance company in that scenario as an association means you're less likely to look at being dropped from coverage, at being forced into the secondary insurance market, at having your premiums go up because of a history of repeated claims. So there are other sort of peripheral issues that weigh in favor of this type of amendment, even beyond the fact that you have to do it in order to assess these costs to your unit owners. So go ahead, Tima, with your next question. I don't want us to spend too much time on this one, but if people have questions, you can put them in the chat and we'll try to get to them later.
Yeah, and I would just say it's certainly less expensive than having to go through collections to collect a deductible amount that the owner thinks is covered by their insurance and the association says isn't, and then so from a cost standpoint, it's a very practical decision to make. The second question is, does parking reassignment require an amendment, even though it has nothing to do with governance? Well, the short answer is that if your current declaration assigns parking as a limited common element, then parking reassignment does require an amendment. The declaration covers rights and obligations to the owners and the association, and it's not just about governance. So the fact that that it has nothing to do with governance, it does not necessarily mean that an amendment isn't required. Most condominiums have parking assigned in the declaration itself. So essentially, I would say for the most part, yes. Valerie, did you have anything else you wanted to add? This is a pretty simple question.
So there's two other scenarios, right? One is parking is not assigned and it is a common element. And in that case, a declaration amendment is not required if the association is essentially administering or assigning parking by rules. Then it just is that would be a board decision without an amendment required. There is also another scenario where parking spots are actually deeded parts of the unit. And that is a more complicated scenario, which requires the agreement of the affected owners and would require probably more than just an amendment. It would also require the specific owners with the spots that are being switched to sign off on the amendment, as opposed to an amendment that the association could record unilaterally when the parking spots are limited common elements assigned to the unit. So those are some other things to keep in mind. But Tima is right. The most common scenario is that they are limited common elements assigned to the units by the declaration. And in that scenario, parking amendments would be required to reassign those spots. All right, next question. In our board meeting, when discussing a delinquency of a unit, we refer to the unit number, not the address. Someone has suggested this is too much information for privacy reasons. What number should we use instead? So the short answer to this is that there is nothing that prohibits the disclosure of the unit number in the board meeting. And certainly keep in mind that your unit owners have the right to request the opportunity to review association records, including things like the delinquency report, which would also have that information in it. That being said, we also think that it is a worthy endeavor to try to avoid shaming people by sort of pointing them out specifically, right, in terms of a delinquency, because it just doesn't work. It's not nice. Also, it just doesn't work. So a lot of our clients will refer to the delinquent account by the account number that's assigned by your accounting software. If you're using an accounting software, if you're using a management company that has an accounting software, often there are account numbers assigned to the individual unit owner accounts. We also have clients that have a different internal like reference or numbering system that they use to keep track of which number is assigned to which unit. That makes it harder to identify the unit when referring to the delinquent account. And also you could even use something specific like a parcel number, which again, if somebody was really determined, they could go with that parcel number to the county website and look it up and figure out who the delinquent owner is. The endeavor here is not that you are making, there's no need to make it impossible to figure out who the delinquent owners are, because it's kind of impossible for you to keep that information from the community as a whole, given their right to review records, right? The effort should be to avoid taking a kind of wall of shame approach where you're specifically naming people for the purpose of trying to shame them into curing their delinquency. And the reason that we recommend against that is that it just doesn't work. So do keep in mind, though, there are some scenarios in which this really does matter. The statutes, our governing statutes require that when a board of directors is approving a foreclosure lawsuit, the association cannot move forward with that lawsuit unless the board specifically authorizes a foreclosure against that property. And that doesn't mean that you have to use the unit number in your board meeting minutes, in the motion, or whatever, but you do have to use a specific identifier that makes it easy to understand which unit you were authorizing the foreclosure for. So whatever system you choose, whether it's unit numbers, and that is fine, whether it is account numbers, whether it is parcel numbers, make sure that it's a consistent system where 2 years later, if somebody's looking back at the board meeting minutes, say like a judge, because somebody's challenging whether the board ever actually authorized this specific foreclosure as required by the statute, you want it to be something where you can look back at those minutes and it's clear from the minutes and the motion that was made that the board was authorizing that particular foreclosure lawsuit. Tima, did you have anything to add on that one?
Nope, I would just say this does come up a lot, especially now that with the open board meeting requirements that were effective January 1, 2026. And so, you know, there is nothing that prohibits this disclosure. It's just that clients are understandably wanting to be respectful, and this is the way to do it. As long as you keep in mind, like Valerie said, it has to be clear which unit or lot that is being foreclosed on when it comes to foreclosure specifically. And okay, next question. I think we can move on. Um, Question 4. The RCWs, in this case, the question is being asked by an HOA, are pretty clear on the restrictions for foreclosure and somewhat not clear on liens when it comes to overdue assessments. However, it is not clear at all concerning the accumulation of fines for not complying with the CCRs. Does the 2,000 limit before any foreclosure action apply? So the short answer to that question is the $2,000 foreclosure threshold is based on an assessment only balance. That means that balance does not include interest, late fees, attorney fees and expenses, or any fines, administrative expenses that have been assessed to the ledger. So that means that no amount of fines can qualify for a foreclosure lawsuit unto itself. You have to have a minimum of a $2,000 assessment only balance before you can add fines to a foreclosure threshold balance. As far as the lien is concerned, I wasn't sure. The question was a little confusing. I think what it meant to say it's somewhat clear on liens, but in any case, when you record a lien, in most cases, this is specifically authorized in the governing documents of the association. I have seen exceptions to that, not many, but at least on our side, when we are conducting our initial review of a file, we do look to the governing documents to ensure that that provision is included. Also by statute, this may be the specific foreclosure limit is essentially, think of it this way: it's a public notice that the debt claimed by the association of that, and it puts the owner and essentially the world on notice of the debt that is accumulated for this particular delinquent owner. A lien also is going to be, so in that vein, when and if an owner attempts to transfer title, there is always going to be a title review, or should be. And in that case, if there's a lien on the property, that's going to preclude any transfer of title until the lien is cleared. I think that covers the question and a little bit more. Valerie, did you want to add anything to that?
Yeah, two things. One, I just want to emphasize something that Tima already said. No amount of fines can qualify or result in a foreclosure unless there are unpaid assessments of at least $2,000. And the way the statute requires you to calculate that assessment only balance is assessments charged minus payments made. You don't get to count fines, late fees, interest, or attorney's fees and costs in calculating that $2,000. The legislature on purpose made it impossible to foreclose on fine only balances due. So that's one. And then the other thing that I wanted to just say as an aside is there is a statute of limitations on collecting unpaid assessments. So you can't just record a lien and assume that you're good forever, because eventually they're going to sell and you'll be able to collect everything that's due when they sell. When they sell, you will be able to collect everything that is due that is not barred by the statute of limitations. For non-Wakaiowa condo associations, that statute of limitations is 3 years. For everybody else, Wakaiowa and HOA Act, it's 6. So in 2028, it'll then be 6 for condo associations, assuming, especially those that amend their documents to be consistent with it, although it'll be interesting to see what litigation happens after that for condo associations where the statute of limitations in their document says 3 years, but the statute says 6. It's unclear to us how that will play out in 2028. So the only thing that stops the statute of limitations from making older amounts due uncollectible is filing a lawsuit. And I just don't want people to think that, well, as long as we record a lien, we're fine and we'll be able to recover whether they sell in 5 years or 10 years or 20 years. Because that's just not the case. And the older a debt gets and the larger the debt gets, the harder it is to collect in full, the more expensive it ends up being, the more likely litigation will end up being necessary in order to collect the balance due. So as counterintuitive as it seems, you want to act relatively quickly. And I don't mean like unreasonably fast, right? You want to look at the overall balance due, the age of the delinquency, the composition of the balance due, and consult with your association attorney about a reasonable approach that is proactive enough to hopefully allow you to avoid litigation and excessive costs of collection, but that is still proactive enough that you're not looking at dealing with losing the ability to collect because of the statute of limitations or other issues. All right, next question. In a perfect world, the developer creates CC&Rs and bylaws at the time the HOA is created. Those documents are not voted on by the homeowners. If a developer did not create bylaws when an association was created, can the board adopt an initial set of bylaws, or will 75% of the current homeowners need to vote to adopt the initial set of bylaws? So the short answer to this question is that it does depend what statute you are governed by. For example, the HOA Act does not specify what percentage is required to adopt or amend bylaws. This is typically specified in the governing documents for the community. And if it's not, then by default, a majority vote of the owners would be required to adopt that initial document. Sometimes, like I said, the CC&Rs will specify a voting threshold. Sometimes you might even find that in the articles of incorporation. So you want to have an attorney review the existing governing documents that you have to tell you what percentage of your ownership has to vote in favor of those bylaws to get them adopted. Under Wakaiowa, for example, unless the governing documents specify a different percentage, a majority vote would be required to adopt or amend bylaws. So if you want to look at that provision of Wakaiowa, it's 6490-455 subsection 8. And of course, starting January 1 of 2028, that will be applicable to everybody. So it is unlikely, unless your declaration specifies a percentage of 75%, it's unlikely that you would need to get that level of support from the ownership. But it is likely that you would need to get at least a majority of the owners to vote in favor of that initial set of bylaws. One other thing to keep in mind is that occasionally we see declarations that make it clear that bylaw, the adoption and the amendment of bylaws is something that can be done by the board without a vote of the homeowners. And in that scenario, it may be possible for your board to adopt the initial set of bylaws. But again, there's no way for us to answer this question for any specific community without knowing your governing statute and what is said in your current governing documents. Tima, did you want to add anything to that?
No, I think that covers as much as we can without additional information or providing legal advice. So number 6, can a late fee be recurring, or is only one late fee allowed for a given delinquency? For example, if the January monthly dues obligation is missed and a late fee of $25 is assessed, and that delinquency continues to be past due for 4 months, can the $25 fee be added every month? At that point, the total late fees would be $100. So the second part of the question is, or comment is, if so, late fees would accumulate significantly if not only January, but February, March, and additional dues are also delinquent with each of those missed months payments accruing. So the short answer to that question is yes, you may assess monthly late fees as long as your governing documents authorize recurring late fees. The fee must be considered reasonable. So even if your documents have a late fee, if it's something that appears to be unreasonable, we, for example, if we were representing you, might suggest that you, or would likely suggest that you would adjust your late fees to a lesser amount than what is specified. It doesn't happen often, but we have seen those certain cases. And what's considered reasonable is, of course, a sliding scale based on what your monthly payments are. If your monthly payments are $2,000, a $200 late fee might be considered reasonable. A $200 late fee on a $300 monthly assessment is obviously not going to be considered reasonable. So that's just a little mention there. Late fees are intended to induce an owner to make monthly payments, not to be punitive upon the owner. And a board can always, even if late fees are allowed in their governing documents, these are often when an owner is attempting to resolve the debt, sometimes this is a negotiable amount on the payoff for the owner, and boards are always allowed to waive late fees if they decide, some or all of it, if they decide they want to do so. Um, so I'm going to add here that we strongly, at least on, we do, and I think most association attorneys would recommend that an association that does not have a current collection policy in compliance with the new laws in effect, as far as at least as recently as January 1, 2026, where there have been some significant changes to collection, collection, the standards of collection and what exactly must take place. We do recommend that you adopt one in order to ensure that you are not facing court scrutiny in the event that you are not adhering to the new laws and an owner challenges any type of late fees or assessments that have been applied to their ledger. I would also want to add that since January, and I'm not going to get into great detail about it, but we've talked about it ad absurdum on this Q&A, but one of the specifically regarding late fees, any account that becomes delinquent on or about January 1 of 2026 or after is subject to the new laws, which do regulate exactly how much of a late fee can be assessed during that initial notice period given to an owner. That is $50 or 5% of the assessment amount, whichever is lower. So just be aware of that. Even if your governing documents authorize a $100 late fee, during this notice period, this initial notice period that has been made into law, like I said, for delinquencies that start on or about January 1, 2026, this new limit on late fees does apply. I think that covers late fees. Val, did you want to add anything else?
I just want to clarify that the limit in the statute only applies to the first month until you send a notice that complies with the new statutory requirements. And until you send that notice, you cannot charge any additional late fees after that first month. And that first month is the one that's capped at $50 or 5% of the unpaid assessment, whichever is less. So if you want to hear more about that, go to our YouTube channel and look at like the last 2 or 3 months worth of videos, because we have gone into great detail about the 2026 changes around delinquencies. We also did it last July when these the bills from the 2025 session were codified into law. So we talked about it as early as last June and July. But again, I think we talked about it in pretty great detail in November and December of last year, and again in January of this year, and probably multiple times since then. All right, next question. Our budget for insurance is over budgeted for the year. Our premiums went down. I mean,
Good
yeah,
for you.
that's like the only time I think I've been doing this Q&A that I've ever heard that. So
I've
great.
never seen that.
The board wants to move some of this savings to other lines / new expenses. Should a new budget be ratified for this? I think the answer to this question is generally that is not necessary. The board is allowed to reallocate funds. They could put it into a reserve account. They don't have to, ratify a new budget in order to do that, unless the governing documents specify otherwise. So do take a look at the governing documents to make sure there isn't any unusual language that would require notice before doing that. And I think what we come back to when we're answering this question is the reminder that a budget is a plan, and there's no way to know with 100% certainty what your actual expenses will be until you get the bills for those expenses, right? So just like I put together a household budget for my 2026, and I have, maybe I have $50 a month that I'm putting into an account for car maintenance. Well, if my car gets totaled, then I'm going to have to spend more money to replace my car. And so a budget is our best guess at a spending plan for the year, but it's not a contract. And unless you are going to be spending the money in a way that is, wildly out of line with past practices or with sort of the general budgeting approach of your community in the past, we don't think you would need to ratify a new budget to reallocate money that you have extra of because of lowered premiums. I will remind everybody that there are some restrictions in the statutes on investing in securities specifically things like that do require a vote of the owners. So if you're doing something specific like that, the answer to this question might be different. But if it's simply a situation where you guys have $500 extra a month in the budget because your premiums went down by that much and you want to put that money into the reserve account, there is no need to ratify a separate budget to provide for that. Just make the transfer into the reserve account. Tima, did you want to add anything?
Nope, I think that covers it. Question number 8. Thank you for your information on resale certificates. I didn't know about the second request fee. We currently get resale certificates from the listing realtor. Then other requests for the same information will come from the title company or the lender, etc. Can we apply a fee for these as well? Short answer is that by statute, the maximum fee an association can charge for an owner's resale certificate is $275. The fee must be reasonable and could be lower than $275, but cannot be higher. So as a bottom line, there's just one fee as far as that's concerned. Now, when you receive requests for financing forms or other loan-related documents that are not addressed by the statute, these are going to be covered under that same $275, just the same way that any other transfer fees would be. It is important to know that there is a new law that is going into effect, which adds a provision allowing for a $100 rush fee under very specific circumstances. So you'll want to ensure that that's actually authorized before you consider adding that fee. It also prohibits charging for copies of documents that are already available in electronic format and available to owners through a website or a web portal. So you can't charge for something that an owner or that anyone could reasonably find online without charging a fee. So just sort of common sense there. It also states that an association cannot require an owner to contract or establish an account with a third party in order to provide payment or accept delivery of the resale certificate. So it's sort of an added threshold there. Again, I think that was signed into law, but hasn't gone into effect yet until June. You can correct me on that, Valerie, but I do think that that's going to happen. The new rule.
That's ESB 1500. That's the resale certificate bill. And Tima recapped that it reemphasizes that the total cost for a resale certificate may not exceed $275. And this was in part because we've seen, a resale certificate fee of $275, but then a document fee of $150. And then this, like all these additional fees that are being tacked on at the time of closing. And so for the resale certificate itself, the maximum fee is $275, $100 rush fee under certain circumstances, which I would need to look again at the text of the bill to tell you exactly what those are. But it's a pretty limited set of circumstances. You can't bill for documents that are available to owners free online. I will offer that things like the financing forms, transfer fees, those types of things are not addressed by any of the statutes that exist or by the bill that we are just referencing. And we see a lot of management companies, for example, bill a title company or bill a selling owner to provide those separate documents. And the statutes are silent on that. And that's outside of our purview here because we don't represent or advise management companies. Our representation and advice is limited to community associations. So the cost for the resale certificate is absolutely capped at $275. You can't tack on additional fees for components that you're required to provide in the resale certificate. And I don't think you can bill extra to send a second party a copy of that resale certificate that you've already billed the selling owner for. And if there is if a long enough period of time lapses between the last request and the next request, then the underlying statutes, I think they provide for essentially an update fee. I'd have to look at the statutes to make sure that that's correct. And that if a resale certificate is old enough, then you can charge the $275 again for a new resale certificate. But I'd want to look at the statute again to refresh my memory on the time frame on that. So This is a change for all communities that have a resale certificate requirement right now. So the change, the ESB 1500 that we were talking about that was adopted this legislative session and will take effect in, I think it's in June of this year. It might be early July. That is going into effect for all community associations that currently have a resale certificate requirement. So condo associations and Wakaiowa communities. Currently, communities governed by the HOA Act don't have a resale certificate requirement. But again, in 2028, we all will because of the Wakaiowa for All date, which is January 1, 2028. All right, I've got a real short one for the next question. Owners request copies of invoices for financials provided by the board. The answer to that question is yes. Financial statements are considered an association record. If you look at 6490, 495, that is the records section of Wakaiowa, and there is a nearly identical section in all of the other governing statutes. And almost every invoice would likely have to be made available to any owner who requests the opportunity to review it. The one exception that I can think of off the top of my head is that sometimes attorney fee invoices might have privileged information in them. And in that case, you would need to redact that privileged information so that you're not waiving attorney-client privilege by providing the owner a copy of the invoice. I don't think you can refuse to allow them to review the invoice entirely, though. I think the obligation would be redact and then let them review it. Tima, did you want to add anything to that one?
No, I agree. I think that covers this, a simple answer to a simple question.
Yes.
Question number 10, YouTube channel for meeting records. Is an association permitted to create its own YouTube channel to record meetings? This would allow for the board to maintain its own records and easily transfer them to new management companies if necessary. So the short answer is probably this is permitted as long as the channel is only accessible to authorized owners with regard to confidentiality, and as long as the governing documents do not prohibit it. And we can go into more detail on this if if Valerie wants to get into more detail. We could talk a little more about some of this. I haven't actually seen this with a client yet. I based on the question, the way it's presented, I would say I don't see any particular issues with it. Again, the main concern would be accessibility and confidentiality, because the things that are being discussed in meetings should only be accessible to those who were actually at the meeting or supposed to be invited or included in the meeting. So you'd have to make sure that there were some restrictions in place on that. So Valerie, did you want to go into more detail, or did you want to wait and see how much time we have?
My knee-jerk reaction to this question wasn't so much about the YouTube channel, because you can absolutely control the accessibility of that channel to make it private and only viewable to people that have the link or whatever. But my bigger question was, like, why are you recording and then keeping recordings of your board meetings? Because that creates a whole new class of association records that you then need to have a retention policy around, that you then have an obligation to allow owners to review in the course of a records request review. And on top of that, a recording is not the official record of the actions taken at a board meeting. The minutes are. So if I had a client that came to me and said, is this a good idea and should we do it? I'd want to ask some questions around why they wanted to retain the recordings long term. We have a lot of clients where the board will record a meeting so that the secretary, when producing a draft of the minutes, can reference back to that recording so that they can make sure they've got, like, the person who made the motion is accurate, or the tally of the vote that the board took on a certain motion is accurate. And then that recording is typically destroyed once the minutes are approved at the next board meeting. That makes more sense to me, but keeping them long-term is something that I don't necessarily understand and would want to ask questions about. So those are some of the thoughts that I had when I read the question. That being said, the actual question about, is it okay if we do this on YouTube? Yeah, I think that's fine.
Yeah, I mean, a recording is not a replacement for minutes, and minutes are required. So that is a very important point.
Exactly. All right, next question. ARC committee versus board authority committee. And just for those who don't know, ARC is Architectural Review Committee. Could you clarify the differences between an advisory ARC committee and a board authority committee? Specifically, is an advisory committee required to hold formal meetings and comply with standard meeting notice requirements? What are the primary legal or procedural requirements for both types of committees? Can approvals be conducted through an online forum without a meeting, and do they require a unanimous vote? So I'm going to start by referring you to the meetings section of Wakaiowa, 6490 445, I think, which is as of January 1, 2026, applicable to all communities in Washington state. So we're all subject to these rules now. The difference between a committee that is advisory only versus a committee that exercises the authority of the board is kind of exactly what it sounds like. An advisory committee might meet, they gather information, they ask questions, they might go out and look at the site of a proposed architectural modification, and then they put together a report of information and maybe even make a recommendation, and they give that to the board. And then the board at their next open meeting reviews that recommendation and is the entity that makes a decision on that request, on that architectural request. So an advisory committee makes no decisions. They gather information, they summarize that information, they make a recommendation to the board, and then the board is the group that makes the actual decision on that architectural request. That's an advisory committee. A committee that exercises the authority of the board would take it one step further. They would review the application, they would gather information, they might visit the site again, and then at their committee meeting, they would vote on whether to accept or reject that application. And in that scenario, when the committee is the one making the decision, they are exercising the authority of the board in doing so. And committees that exercise the authority of the board are bound by all of the same requirements around board meetings as if it were a board meeting itself. So if you have an advisory only committee, you could arguably not have that committee meeting open to the owners. We're telling our clients to just have them open to the owners anyways, because all of the meetings changes have come from a legislative intent in support of transparency with the ownership. And so why not? If they're meeting anyways, especially if they're meeting on Zoom, but even if it's in person, why not have it be open to the owners? That does not mean, in particular, when it's an advisory only committee, open does not mean owner participation. It doesn't mean the owners get to interrupt and ask questions and be involved in the meeting. It simply means that they get to observe, okay? So for an advisory only committee, the meetings probably, you could make an argument under the statute that the meeting does not have to be open to the owners. Our recommendation to our clients is that they be made open anyways. And you're not making any decisions. You're simply providing a summary of your findings and maybe a recommendation to the board. If you are a decision-making committee, if you're a committee that's exercising the authority of the board and you're the ones making the decision, then you do have to provide 14 days written notice of your meetings to the owners. You have to start that committee meeting with an owner comment period, and you have to make those motions and decisions in full view of the ownership at that open meeting. There is no scenario that I can think of in which approvals could be conducted through an online forum without a meeting, even if the vote is unanimous, regardless of whether it's a committee making the choice, the vote, or the decisions, or the board making the decisions. That does not violate the statutes, in my opinion. So I think that answers all of the questions. If you want to add anything, Tima, feel free. And if the person who submitted the question wants to ask for clarification, or if anybody else wants to ask for clarification, feel free.
I think that answers it as far as I'm concerned.
Great.
I will move on to question 12. Are we compliant with the Wakaiowa meeting requirements if, having moved to go into executive session and close the public part of our board meeting, where no action results from that session, And rather than reopening the meeting to the members for final closure, we just announced by email that no further action will occur and that the meeting has been closed. And so the short answer is I'm happy with everything up to the point where you do not return to open session. So maybe that's compliant. I don't know. We don't have case law. We don't have additional guidance from the legislature. But at a very minimal effort, we would not recommend doing it that way. We would say that even if no decision is made after the topic is discussed in executive session, for transparency's sake, which you've been hearing us say over and over, this is the legislative intent of the meeting requirements that are now in effect. It would be best practice for the board members that were meeting in executive session to return to open session before they end the meeting. And that fact and that re-entry to that exit from the meeting and the re-entry during that executive period should be noted in the meeting minutes in order to honor the intent and to show that you are clearly complying with the law in effect. 649445 goes in, and we've already talked about that, but I'm just giving you the quote again. You can look at the statute. It has very specific meeting requirements, and our interpretation and our belief of what the legislature would intend would be for that executive meeting to be clearly noted in the minutes and for those participating to see when the executive session starts, when it ends, and then you can promptly end the meeting at that point. And just to add, it's just a very small and minimal time and effort to do this and to not have any question of compliance if you do follow that rule. And this is what we recommend to our clients when these types of things, when they are meeting in executive session. Valerie, did you want to add anything to that? I think
a follow-up question in the chat that I'd love to handle because it's an easy one. Is there a way to successfully do that if the meeting is held online via like Zoom? And the answer to that question is yes. It just requires that you either have everybody leave the meeting or remove everybody from the meeting, stick them back in the waiting room, whatever, or you can even create a separate breakout room depending on what level of Zoom account you have. Conduct the executive session, and then you come back into your normal Zoom room, like the one that we're in now, and either you let everybody back in from the waiting room or you bring them back in from the separate breakout room. You reconvene your open session, and you can just say the executive session is over. The board has no further business, and the meeting is adjourned at 10:52 a.m. It can literally be that short and sweet. And that is in part why we recommend that you come back into the open session to properly close your board meeting. Because the thing is, when you call your meeting to order at the beginning of the meeting, right? You conduct all of the open portions of your meeting, and then you make a motion to adjourn to executive session to discuss, whatever the thing is. You haven't closed your board meeting. You haven't adjourned the board meeting. All you did was make a motion to adjourn to executive session. And so you need to go back into open session to then close/adjourn your actual board meeting. Maybe that's me getting overly technical, but it's such a low bar and a low effort and a small amount of time to do it, especially when you have no additional motions and votes to take afterwards, that we think it's the best practice. Agreed. All right, next question. Is small claims court in King County typically a successful avenue for a board to recover delinquent assessments? Is it advisable to confer with our association attorney to prepare for a small claim filing? And is mediation a prerequisite? Boy, I wish I had an answer to this question. I think that small claims court can be, depending on how you define successful. There are some things to keep in mind. In small claims court, associations, all corporations actually, are limited to a judgment of no more than $5,000. That's the jurisdictional limit in small claims court for a corporation seeking a judgment against an individual. And so depending on the balance due, that may or may not be an effective method for you to try to pursue a judgment. Another thing to keep in mind is that the only thing you can get in small claims court is a money judgment. That's it. The court will not enter in any other orders. You can't foreclose. You can't take advantage of a receivership. You can't file any non-money judgment motions. The only thing you can ask the court for in a small claims action is a money judgment. On the flip side, the cost of small claims is much lower than going to court with the assistance of an attorney. Attorneys are not allowed to practice in small claims court by default. You have to make a special motion to the court in order to be represented by an attorney. And so it is far more cost effective. The board or the manager though has to be prepared to fill out the claims forms, get them filed, pay the filing fee, arrange to have the lawsuit served on the owner, and then set a court date. And the question as to whether mediation is a prerequisite, it's not a prerequisite, but mediation is a required part of the small claims process. So once you file the small claims court action and serve the owner, there will be a court date, and then the judge will not issue a judgment until you have gone through some sort of ADR process like mediation. So that is a required part of the process, but you don't have to have completed it before you file the action, because the small claims judge will require you to do it before they will consider entering a judgment. So the ways that you evaluate whether small claims is a good option for you would include things like how much is the balance due? Does the owner have resources from which you can collect on that judgment? So have you done an investigation to determine whether they have bank accounts and wages that you can actually garnish with the judgment? Because if you can't garnish to effectively collect on a judgment, then the judgment's about as valuable as the paper that it's printed on, right? Is there a board member or a manager who is willing and able to prepare the documents, appear in court on the association's behalf, conduct the mediation or participate in the mediation that will be required by the small claims judge, etc.? And then once you have the judgment, what are you going to do with it? That would be a point at which you could essentially give a copy of the judgment to your association attorney. They can have it entered in superior court and use it then to garnish wages and bank accounts, again, if that information is available and the owner has those things. So one of the parts of the question was, is it advisable to confer with our association attorney to prepare for a small claims filing? I would say you should confer with your association attorney as you make the decision of whether small claims is a viable option in your particular scenario, because your attorney will be able to walk you through things like the jurisdictional limit, the mediation requirement, and what that looks like, and all of the things that you can't do via small claims that you could do if you filed, for example, a foreclosure lawsuit. A foreclosure lawsuit allows you obviously to foreclose on the unit. It also results in a personal judgment against the unit owner, but it also has things available like the ability to appoint a custodial receiver if the unit is not owner occupied, who can then take possession of the unit, get it rented out. That rental income is applied against the receivership costs, but then against the delinquency as well, once it reaches the break-even point. So I think consult with your association attorney about if and when small claims is a good option for you. We have certainly worked with clients that have either been sued in small claims or have brought small claims actions to review their documents before they get them filed with the court. And that seems like a reasonable thing to ask your association attorney to do. I think that covers all of this question. Tima, is there anything else that you can think of?
No, I mean, I think there's just a series of questions that go into play when you consider filing a small claims action. And the main thing to know is that attorneys can't appear in small claims court. So if you do need assistance, do contact your association attorney. They can at least give you some guidance.
Yeah.
And help you. And like Valerie said, if you actually do obtain a judgment, then, that's something we can help you collect upon as long as the owner is collectible.
Great. Okay, we have some questions in the chat, and I'm not sure which ones we have time to get. Actually, I'm not sure if we have.
Gosh. We thought we'd have more time.
I will say there is one follow-up to the small claims, which is how long has the mediation requirement in small claims court been required? I can't answer that question. It's been required for as long as I have been advising clients on small claims, but that I've been in this practice area for 17 years, but I probably have only mostly dealt with small claims the last maybe 7 or 8 years. It's not a huge part of our practice, so I can't pinpoint when that requirement sprang into being. I think probably we're going to have to save our chat questions for next week. So at least we have our like starter seed questions for next week. If you all think of additional things you'd like us to talk about next week, please send those to info@condolaw.net. And thank you for joining us today.
Thank you. Have a great day.